Hi, my name's Daryl and I'm an adoptee, and I'm making this video so I can try and impart my knowledge of the process of an adoption discharge here in Australia to other adoptees that might be considering it. The process is typically clouded in mystery. A lot of the court cases aren't published, so and it's illegal to do that. So rather than talking about my court case, I'll generally talk about what adoption discharge is and my experience within it. So to start with, I was adopted around 1964, and adopted at 2 weeks. I was actually fostered, relinquished at 2 weeks and fostered for 2 years, and then I was adopted at about 2 years old. Lots of backstory behind that, but this video doesn't concern that. So what I want to talk about is the adoption discharge. So what is a discharge of adoption? Basically, it means that if you want to, as part of your healing process perhaps, want to find your true identity and then want to take one step further and actually become the person you were once. In other words, when you're born, there are certain laws in place. In my case, there was laws that said the government could take the original birth certificate and put it away in a file and seal it so that you weren't allowed to access it. They recreated a new birth certificate when I was adopted. So for 2 years my name was Shane. And then after 2 years, my adopted parents changed my name to Daryl, and I got their surname and everything. And the paperwork was amended by the government as if I was born to my adopted parents. So part of the process of the discharge means that some people have said it's divorcing your adopted parents. I don't call it that significant. Basically, you are trying to be who you are, really. Your original birth certificate becomes valid again, and then you can be that person legally. So for example, if you have found and reunited with your birth parents or parent perhaps, or you've found that you have brothers and sisters or something like that, and you want to be part of that family legally, this is the way to do it. Unfortunately, the government makes you choose, and you can't be legally then, a son or daughter of your adoptive parents. So you've got to consider this, any legal implications of what that might mean to you. You can do certain things in law to, maybe avoid, if you've got inheritance issues, you can actually put that down as part of the decision the judge makes. But we'll get to that later. So firstly, what is the process? In different states and territories of Australia, they have different laws. It's unfortunately not federal, so it's not one law that applies to everyone. It is different in every state. In some states like Victoria, you can apply for a discharge to a magistrate's court. Unfortunately in Queensland, you have to apply to the Supreme Court of Queensland, the highest court in Queensland, which is what I had to do. The reason I was doing it was I didn't want the government to dictate who I was, basically. I was putting a will together, and I was wanting to mention my true brothers and sister in my will, and my father. And when I went to do this, the legal guys said, well, I said I wanted to leave such and such to my brother, Alan, to my brother Joel and Conrad, and such to Catherine, and my father Alan. And they said, well, you can't say that. And I said, can't say what? And they said, no, you can't call them brother, sister, father, because they're not. And I said, well, they are, because I have DNA proof. And they said, no, it's not about that. It's the fact that legally, because of the adoption, all that is severed. And I didn't like the idea that, he is my true father, they are my true brothers and sister. And the law, again, was getting in the way of me being who I truly am. I didn't want to disconnect from my adopted mother, who is still alive, and raised me, and I love. It's nothing to do with that. I wasn't trying to divorce her. I was trying to be me, my true self. And if that's important to you, like it was to me, then you have to go down this process, unfortunately. We're lucky in Australia in that we've had a Prime Minister that has apologised for the forced adoptions, stolen generation, and the forgotten Australians. And they're all impacted by the decisions of governments of the past. Unfortunately, laws haven't caught up completely. So an apology is one thing, but making it right seems to be another thing that escapes most governments. But then again, in Australia, like I say, we have this adoption discharge possibility open to us. In other countries like New Zealand, it's a very archaic process, and I think they're reviewing their laws now in 2021. But whether they get the right result, who knows? And in America, I think it's even harder between the states. Some states still don't allow you to access your identity papers. It's all hidden away. So in a way, we're lucky. So one thing about finding out who you are, the other thing is actually taking the next step to say, well, do I want to be legally that person or not? Now, it may not matter to you. A lot of adopted people, they don't care. And they don't want to know. For me, it is important. The truth is really important. And again, why a document like a birth certificate should be a legal fiction, I don't know. And I don't know why that hasn't been addressed in law. But I suppose the one thing we can, like I say, be happy about is that we can offer, apply for a discharge. So, I can talk about Queensland law because that's what I've been through. And I really can't talk about other states, but many other states have similar laws. So, first of all, when I embarked on this process, what I tried to do was find a lawyer in Queensland that would go to court for me and would represent me to do this. Unfortunately, most lawyers that I contacted, and I contacted maybe 30, didn't have any experience whatsoever in this area of law. I did contact a couple of barristers. Each of those guys wanted $100,000 and plus the fees of a lawyer as well, which is another $40,000 to take that to the Supreme Court. Of course, I don't have $140,000 lying around. Some people are able to get legal aid, but I didn't qualify for that. And I know there has been some cases taken to court through legal aid. So, if you can do that, great. If you can't, or you can't afford $140,000 plus, I suggest you do it yourself, which is what I did. We're a citizen of Australia. We can apply to a court just like anyone else, but you have to prove a case. And that is very daunting for a lot of people. So let me explain the kind of case that you might have to prove. So let's talk about the Queensland law. I've got something written down here. So the Adoption Act of 2009 in Queensland, Division 7, Discharge of Final Adoption Order, 219 grounds for discharge. The grounds are: 1. A final adoption order may be discharged on any of the following grounds. A. The order was made or something was done for the purpose of making this order. 1. Because of a false or misleading document or representation. Or 2. Because a person acted fraudulently. Or 3. In another improper way. B. A consent required for the adoption was not given freely and voluntarily by a person with capacity to give the consent. Or C. There are other exceptional circumstances that warrant the discharge. Now, in Queensland, of course, you've got a number of points you could try and prove. In other states, I think New South Wales, you only have the exceptional circumstances clause. So let's go through each clause, if you like, each ground that you might have to prove. So the order was made or something was done for the purpose of making the order because of a false or misleading document or representation, or because the person acted fraudulently or in another improper way. So cases aren't necessarily published, and that's another reason why I'm making this video, because as adoptees we don't really know the right route to take, and even if you talk to a court, they're not sure either, because these things happen rarely. I think only about a dozen have been discharged in Australia. Some of those that have been discharged rely on the exceptional circumstances or special circumstances clause, and others rely on the acted fraudulently or misleading document. So the ones that have proven through fraud usually rely on someone forging someone's signature for a consent, or if it was acted in a proper way, maybe the law of the day wasn't followed. For example, people have stolen children, it has happened, where they, the paperwork isn't followed properly, and the church and the medical profession have been involved in things like that. I know of a case in Tasmania like that, where the government actually applied to get the discharge happening because they were embarrassed, I imagine, about the circumstances of the lady. I've heard of cases that succeed and don't succeed. The ones that succeed tend to be reliant on this clause of exceptional circumstances. Other ones that don't succeed, I've heard of cases where someone that was in an adoptive family had met his birth parents, the father was rich, and had left an amount of money to his son, but because he wasn't his legal son, he couldn't challenge the will because it wasn't enough money or whatever. So a lot of these cases that come up to challenge wills and things like that, I think judges look at poorly, because they think the motive there is to, for example, challenge a will. And as you heard, that isn't a grounds for a discharge. So, I think you have to prove that ground. And the other thing that judges tend to do, from what I've read, is that they want to not undo the condition of adoption, because they think if you undo it for one, then many will be affected. So they tend to allow you to, bring up points of law. If you have information about what happened to you, as a baby, and you can get that information, and there's some false processes there, then you could probably find proof for grounds 1 or 2 under A or 3. The trouble with trying to find this information is a lot of it is hidden still. The government, even when you ask for documents and you have a right to get those documents around your birth, the government will sometimes give you just some documents, won't give you a lot of documents. I myself applied to Queensland government over a period of 35 years, and I was drip fed information. It was only recently, in the last couple of years prior to my applying for my discharge, that I found information out that unsettled me, that wasn't true but was on record as being true, which was explained the delay between when I was born and then 2 years later when I was adopted. So that was false. So actually, when I applied for my discharge, I applied under every ground I could, and I think I had grounds for all of those rules. But ultimately, like I said, judges, you have to prove it indisputably, and a lot of the people involved in the past aren't alive anymore. In the case of my birth mother, she's not alive anymore, so I didn't have her as a witness. And even what she told my birth father, it was all hearsay evidence, so it couldn't be relied on. in court. So, you know, there's a lot of minefields through that. I think the simplest way, if you're an adoptee affected by your adoption and you want to discharge, is to apply under the exceptional circumstances grounds. That's the ground that tends to be published that people have got their discharge under. Exceptional circumstances aren't defined in law, of course, so it's up to a judge's discretion what they might be. But typically they are under mental health grounds. So the way you might prove that, for example, is going to see a psychologist or a psychiatrist over several visits, talk about your past, talk about your adoption. One of the cases that I recall, the lady involved had been abused by her adoptive father, sexually abused, so she was able to apply under exceptional circumstances and have her adoption discharged because she didn't want his name as her surname, and wanted to go back to who she really was because she had found her history. Even though her birth parents weren't alive, she had found the history good enough to satisfy a judge. So, getting back to the mental health grounds, exceptional circumstances, if you saw a psychologist, for example, there are multiple things that affect adoptees through their lives. Some medical assessments might include post-traumatic stress disorder or hypervigilance or depression and other factors. Now, there's a book that I should talk about. This is called The Primal Wound, and it's by Nancy Newton-Verrier. She's a psychologist in the USA. And when you read this book as an adoptee, it does ring true for a lot of the things that are in it. The diagnosis, how you treat other people in relationships. A lot of it, you know, classifies you into certain types of people as an adoptee. Typically, you're compliant, or you're either a compliant adoptee, or basically you're kind of a renegade in your adopted family. So I hadn't read the book when I saw my psychologist, but afterwards it sort of rang true. Some of the things that I had been experiencing all my life, I was able to sort of pinpoint and understand myself a bit better. But like I say, my motivation was always to find out my true identity and be that person. I didn't want the government telling me who I was falsely. And the other motivation obviously was to be legally recognised as my true self. I also didn't want things on record that weren't true. And even though I had supplied DNA reference and proof to the government, they didn't change their records. They would not change their records. People in New South Wales that have applied for, these days, I think it's only recently, last year or so, you can actually get a birth certificate which is a combination of your original birth certificate and your adopted birth certificate. Trouble with that is, whatever's on record comes into that piece of paper. So it doesn't sever any connections, it doesn't change anything in law. All it says is, this is one set of parents, your original birth parents, and this is the other set, which is your original your adopted family. And it may not list any brothers and sisters that you may have in either family. It may not list your birth father, because that information usually was disregarded back when I was born. They didn't care who the father was. All they cared about was the signature on a consent form, which then alleviated their responsibility. And, you know, when they talk about forced adoptions, there was a lot of pressure and coercion applied to mothers to sign that consent. So adoptees, you know, if you do research your history, and, you know, what I learned was, you don't just believe what you read, you know, just because there's a signature on a consent form doesn't mean it's the right signature, and doesn't mean that a mother was consenting. So, you know, something to take on board as you look into your own history. There's a reason they call it forced adoptions, because there were 100 ways that religious organisations, society, medical profession, governments influenced the mother and took away any support she might have to bring up the baby. So, you know, don't just blame your birth parents. I think there's a backstory that we all have to find out. So getting back to that exceptional circumstances ground, you have to, get an expert's opinion, and that, like I said, might be a psychologist or psychiatrist based on mental health assessment that you might go through with that person. So you'll have to see them for several visits until, you know, they work you out, or hopefully do, and can actually write something down for the court. And again, there's a way to write that down. Anyway, the process of going to get a discharge is that you apply to court. It's a simple, pretty much a simple form, and you talk about what grounds you're going to apply under, and then you send that form to the court, but you also have to send a copy of that and any affidavit you write, talking about your history and the grounds, and any assessment of mental health to every respondent involved. What I mean by a respondent is it's an application. So the adoptive person is making the application, and other people are responding to the application. And those people involved should be anyone involved in the adoption, directly involved in the adoption, i.e. birth mother, birth father, and adoptive mother and father if they're all still alive. Also the government, so the specific department in the government that looks after adoptions, they would be called as a respondent as well. So everyone there needs to be given the chance to come and have their say about whether they support or they don't support the application in front of the judge. Or they can make an affidavit to that effect, written down and witnessed. So, like I say, you are the applicant. You are going to write an affidavit about what happened to you and why you feel you need a discharge. But obviously it's not a story, it's limited to legal grounds. So try and make it as legal as possible. You're supporting that evidence with whatever you've got. That is your story, when you were born, certificates, copies of everything, proving who you are. If you have other grounds you want to apply under, you have to prove people who they are, like like a DNA report on your birth parents, perhaps, or their birth certificates or marriage certificates or whatever. You have to provide all that information and copy that information and have it witnessed by either a JP, Justice of the Peace, or a lawyer, and then sent that to the court and everyone else involved, every respondent. In my case, I also sent it to my birth family, my brothers and my sister, because obviously I'm becoming legally back into that family. So any implications it has on any person, they have to have the opportunity to respond to that. Now, I was lucky in my case because my birth father supported the application, as did my brothers and sister. Other people that I've heard, other cases, they haven't been as lucky. For example, there's one case I heard was not granted because the person was abused by his adoptive father, and he didn't want to include him as a respondent to the case. He didn't want them to even know he was going under this process. But the judge said, no, you have to tell them, and when he wouldn't, then the judge denied the case. So, you have to have a lot of inner strength to go through this, because you're telling your story. Some things are very, very personal, like for example, your mental health report. You have to send that to everyone, and they get the chance to read it, right? So if you don't want to share that and not willing to take anything that comes after that, well, probably discharge isn't for you, because that's what you have to do basically. So then you apply to court and they will give you a date. There's usually a pre-hearing, if you like. So in COVID circumstances, which is what I went through, the pre-hearing was on the phone. You call in, the judge is there issuing dates and times. Now, I thought I was ready, so I had my affidavit written. I'd copied that to everyone. I had all my proof that I thought that I needed to prove my case. And what I didn't have was the exceptional circumstances ground, because I didn't think I was going to go under that ground. So it wasn't until later that I decided to do that, which meant I had to change my application. So mine was delayed. So I had a hearing for a date, then I had to delay the hearing a couple of times because the government wasn't ready, and then of course I wasn't ready either. So, you know, the court process, you know, you can write about, you can read about it, you can ask the court, you can ring up and they can tell you the process as much as they can advise you. They won't give you any legal aid at all. They'll just tell you the court process. It's always a surprise, I imagine, for a novice what happens in a court, and it's very daunting to front up and have to be there in court. But the judge will want to see you. It can't be done on paper. So you've applied, you've got a date. If you've prepared enough, you've got your affidavit, which is basically a storyline and backed up by proof. So you have exhibits, which are basically, you know, you've heard of Exhibit A, Exhibit B, Exhibit C. Well, these are the documents that prove what you're saying. You know, if you say, my mother is such and such, well, you'll need to prove that's your real mother. So you'll need a birth certificate for her, or a marriage certificate, or whatever. So there's a lot of paperwork. I think I had probably about 30 exhibits on my application. So when you go to court, once you've done all that and everyone's been given the necessary time to review the documents you've sent them, the copies of the documents, which all have to be witnessed by JPs, and they can be mailed. You don't have to serve them on people. They can be mailed and served in that way. Once you've done that, everyone will have a chance to respond. Some respondents won't respond at all. They'll have the opportunity to do so. They'll be told the court date and such. And they get the chance to come and say their piece, or they get the chance to write an affidavit of their own and submit it to the court. They might come. They might come to court, they might hear it with you. So it's usually under a closed session, because even though you're an adult, the government and the court process treats you like a child. So it's like a children's court. In other words, it's a private hearing. I can't tell you what happened in mine, because they also block any transcript for being shared. And you know, if I give away any information about my court case, I can go to jail for 5 years, I think, or 2 years or something like that. So that's how serious it is. But I can still talk to you about the process, because that's, I think, what's lacking in understanding from a lot of people, a lot of adopted people. It seems very daunting because no one understands the process. No lawyers are there to help you. If they want to help you, they'll charge you for that. So, you know, I think I want to try and help others come out the other end like I have. So, going to court. Typically there's a judge in front of you, and there may be the government there as a respondent. That will be a lawyer, Crown Law, and that person will be there to either refute certain things that you've said, or they might be there to just be like a witness, if you like, and neither support the case or refute the case. Typically, my understanding of civil law and those lawyers means that they have to have a good reason to try and block you. Like if you're, for example, asking for money or something, then you'll definitely have a lawyer on the other side, and you'll probably need a lawyer on your side as well. But don't forget, you're asking for a discharge, and this is your motivation. If your motivation is to try and get compensation, maybe there are other avenues to do that if something adverse happened to you besides just adoption, which in some cases is adverse enough, I understand that. So you're in court, I'm on the right hand side, the government's lawyer and their representatives on the left hand side, and any witnesses I might call, or someone that has a response should be in the court as well. So if you followed the right process, the judge will just check that out and make sure all the affidavits are there, and he's interpreted, because in theory he has already read the material when he turns up in court. So you're there for the first time. He will ask about process, probably whether everything's been served on everyone, and then he'll ask if there's any response from the respondents. Now, they might have a chance to get up and say something, or they might send an affidavit in there and then in front of the judge. And like I say, the judge will have a chance to assess that. In theory, it kind of doesn't matter if someone's going to speak out against it, because the law says the best interests of the adopted person are paramount. So that means that if someone, for example, your adopted parents would say, no, I don't want it to go ahead, well, their view would be considered, but it's not the paramount consideration. I think judges, from what I've read on other cases, they like to keep the whole idea of adoption intact. So that's why they tend to want a lot of proof if you want to say, oh, the process was wrong, or my birth mother didn't consent properly, or something like that. You have to have a lot of evidence there. Or if someone had actually acted fraudulently, then you probably have to have that person admit to that. You can't just accuse them of doing it, and they might have to be a witness. But if you're going under exceptional circumstances, then in theory it's about mental health. So you have to present the exhibit of the mental health assessment to the court. So then the judge will assess the material. They might give you the chance to speak about the application. That doesn't mean to say you have to present the whole case. I mean, you can if you want. I think the judge would probably cut you off if you present enough material. On the other hand, you can't just present no material to the court and then rock up on the day and tell a story. It doesn't work like that. You probably wouldn't get your case, well, you may not even get your case heard, but you may not get your case approved. So anyway, when you do that, then the judge will have the power to say yes or no. And that's final. I don't think there's any appeal process in place. So, you've got to make sure you're ready to get the bad news as well. In my case, it was good news, so that's great. Then the court has power to do other things in relation to that. For example, if they're reissuing your original birth certificate again, then they might say, okay, what do you want your name to be? I know it sounds really crazy, but you'll have to think about whether you want to keep your original name, whether you want to add a surname to the back of it, whether you want to go right back to being the person you were born as. It's really daunting, these decisions for adoptees. But what I did was I put my original surname, as if I was born to my original birth family, the name that I would have had in that family. But I understand that some people don't want to change the name, and that's fine too. So the judge will issue a directive to birth, deaths and marriages to say reinstate the original birth certificate and change the name. And in the process of doing that, for example, if your birth father's name wasn't on the certificate, the original certificate, then you can put that on there as well, because that's your chance. I don't think, as far as I've heard, there's any other way to do that. Even supplying DNA evidence to the government, they won't change that record. So the discharge, like I say, not only do you get to have your adoption discharged, but you get to change your name. And there are other things a judge can do relevant. In fact, the law is quite wide in saying that anything the judge thinks is relevant. So you can actually ask the judge for a few things. For example, you might want to ask the judge anything to do with inheritance. For example, let's say you have an inheritance due from your adopted family and they're supporting you in this. You don't really want that to go away because they're not legally your your parents anymore, right? So you might ask the judge to maintain anything that happened prior to this discharge legally. Like if there's a legal document for a will, that might be maintained. Also, because you're getting the power to be, your true self, and you are legally in your original family, then maybe you can challenge any will there as well. So you might want to, give yourself the right to do that, or maybe you don't care about that. I personally don't care about all that stuff, but luckily the judge put a clause in mine that allowed for this to happen. So, like I say, you can actually ask these things of a judge as long as it's reasonable to do and it's relevant. Then, like I say, the judge can make certain orders, as long as the orders aren't fought by the government. Typically, when you arrive in court, the government lawyer is going to be calling you. He's going to be saying, I agree with this, I don't agree with that. And maybe you want to change your application. Maybe they're helping you with the application. Maybe they're not helping you and you feel like they're against you. Well, you don't change your application then. Go to court, let a judge hear it, ask for what you ask for. Or you can just agree with the lawyer of the government, as long as everything is there that you want. And then that document recommending to the judge, what the order should be. If that's agreed by both parties, then it's easier for the judge to say, yes, I'll do that. So, that's the experience. The time in court doesn't take long, you'd be surprised. Once you're called and taken into court, they close the court. In other words, anyone in there has to leave, besides the interested parties, the respondents. And then it takes about 15 to 20 minutes for a case to be heard, I imagine. Generally, as long as there aren't any complications, I suppose. And the judge may make an order straight away, or they may come back and deliberate or have a think about it and make an order later. Like I say, you don't really have a chance to influence the judge beyond the court case. So like when you're in court, you've submitted all your documents. If they're all in order, they're accepted, and then the judge might say, do you have anything else to say, anything else to add? And then you can present your case, you can highlight certain areas of the case if you think that it'll help you. Ultimately, I think what you're trying to get across is your motivation, perhaps, for doing it, and how you think you'll be after you're doing it, and what ramifications it might help you with, for example, mental health if you've gone under those grounds. I think the judges like to hear that. So anyway, like I say, after that, if you're successful, the judge will make an order for the things that he agrees with, and one of the first step would be to change that birth certificate. So they reinstate the original birth certificate, they make any changes that you've applied for, and then that might take six weeks or something to do that, and you get that piece of paper. Then of course you have to set about changing every single form of ID you have: credit cards, driver's licenses, Medicare cards, if you own property, land titles, anything you can think of, passwords almost, because you have to change all your IDs perhaps. So, for me, that was fine. I mean, it's a horrible thing to do, but it's something to have to be done, and to be honest, the discharge was better. After you get the discharge, you feel like it's a celebration, but you feel like drinking champagne. but you don't. I mean, it just feels so weird because it's like, well, I deserve to be who I am anyway. You know, people that aren't adopted, it's not equal, because those people don't have to worry about proving who they are and going back to a court to prove who they are. I mean, as adoptees have to do all this stuff to just prove who they really are. So there was a sense of injustice prior, and now after, there might be a sense of belated justice. And you know, you sort of take that in. It takes a while to soak in. If you're on a path to better mental health, then it's a good step to make, because it lets you let go of the past and you have a new future, if you like. You know, those things that happen to you, if, for example, you're abused or something like that, if that happened to you, yes, it's part of you, but you've done something to close that door. And so I think it's a great step for an adoptee that wants to have a chance to live the rest of their lives the way they want to live and not be a victim of adoption, if you like. I will say one more thing about this. The other thing I did after the discharge was that I had to try and make sense of what happened, and I couldn't understand, you know, through going back and reading law and stuff like that, you know, the laws that applied in, you know, when I was born, which is 1938 law, and then at the end of the year that I was still under foster care, and then the law changed, and then I was adopted, so there's another law again, not just adoption law, but there was also foster care laws and things like that, time in care. So I had to try and navigate all that law and understand what applied to me, and then try and prove a case. And believe me, it's not written in a way that you can understand it. So it's very hard to navigate through that. But there were certain things that I picked up during the course of my research and all that. And that was, you know, the weird wording in adoption law, like, and I could never really understand why humans thought it was okay to take a baby off one woman and then give it to another as if nothing would happen, you know, as if babies wouldn't be affected by that. So, you know, I researched it a bit more, and I traced some of these laws back into America, back into the UK, and I sort of understood now the injustice of where a lot of that law came from. So I did write a book, which is not the reason for this video, but it's called A Timeline of the Injustice of Adoption Law by me, Darryl Nelson. I had put it on, self-published on Amazon, and also on Kindle. You can get the hard copy book, or you can buy it on Kindle. But I mean, if you're interested in the background as to say where the best interest of the child came from in law, the definition came from in law, or why people thought it was okay to take babies off women in law, then I did have researched all that. It goes back a long way. So, you know, these things that I do, I don't know why I'm doing it. I think that I'm helping other people. I'm trying to help other people. I don't really know what motivated me, except a sense of injustice and a need to be my true self. So having gone through the other end, it's now been about a year since I did the discharge. And, you know, I'm feeling better about myself and my way forward. And I think, although I tend to regress sometimes, and there's certain triggers that hurt me, and believe me, the discharge process is not easy. So if you're going to be hurt, and it's very easy to get hurt through that process. So you got to keep adoptees are great at compartmentalizing things anyway, right? So you know, what I tended to do was try and separate the legal self to my me as an applicant, to my emotional state, if you like. Sometimes I was successful, sometimes I wasn't. But believe me, it doesn't really help too much to, you know, stand up and cry in court. So you sort of have to be, you know, kind of strong. So anyway, if you find this video interesting, if you think it helps you, if you want, I mean, I'm not a legal person, I have no experience in law, but I can read and write. So, you know, you can read the law, read what you have to do to apply for a discharge, and if you've got $1,000 for the court application fee, then off you go. I'm hoping this video might help people that are considering it, you know, understand what it is. You're not divorcing your parents. You know, legally you are being who you really were originally. But, you know, why leave a legal fiction? You know, you can still maintain your relationships with your, you know, adoptive family and your birth family, and you don't have to sever anything. I mean, legally, you are being who you truthfully are, who you were when you were born. So I think that that's really important. I don't know who would want you to be otherwise, unless they want to live in a fantasy land, right? So you're not really severing emotional relationships you have, unless you want to, I guess. So if you have, if this is interesting, if you have comments or questions, write them down. Maybe I'll put another video together. This is the first one, but if there's specific questions that you have, happy to help. So anyway, there you go, and good luck, and I hope things work out. Okay, bye.